Breaking. Mundubile asks court moves to disqualify President Hichilema from 2026 elections. Good day, viewers. Welcome to InspirAfrica Official. Tonight, Zambia's political arena is on edge. A storm is brewing between President Hakainde Hichilema and Patriotic Front leader Brian Mundubile. Mundubile has officially asked the court to disqualify President Hichilema from contesting the 2026 general elections, claiming that the constitution itself may bar him from returning to the ballot. But what's really behind this move? Is it a genuine constitutional concern, or a calculated political strategy to weaken the UPND before 2026? As the petition hits the judiciary, reactions are pouring in from across Zambia. Some say this could ignite a legal war that reshapes the next election. Others warn it's a distraction from the real issues. Stay with us, because what's unfolding right now could determine whether President Hichilema even appears on the 2026 ballot. Picture this: the sitting president of Zambia, the man who fought for 15 years to claim state house, the leader who promised constitutional integrity and democratic renewal, now standing accused of the very violations that could bar him from seeking re-election. What happens when an opposition politician takes the extraordinary step of asking the Constitutional Court not just to challenge a policy, not merely to question a decision, but to disqualify the sitting president from ever holding office again? What does it mean when the accusations center on the Constitution itself, the sacred document that every president swears to protect and uphold? Can a president's own constitutional amendment process become the weapon that destroys his political future? Is this a legitimate legal challenge based on constitutional breaches, or is it a desperate political maneuver by an opposition sensing its own weakness heading into 2026? And perhaps most critically, what does this mean for Zambia's democracy when the Constitutional Court becomes the arena where presidential eligibility is decided, not just in retrospect, but preemptively, before voters even cast their ballots? The stakes couldn't be higher. The implications couldn't be more profound. And the battle lines have never been more clearly drawn. The revelation came to light on Monday, November 3, 2025, when documents were filed at the Constitutional Court in Lusaka that sent shockwaves through Zambia's political establishment. Patriotic Front presidential aspirant Brian Mundubile, alongside Taunt's National Youth Secretary Celestine Mukandala, who is also a Lusaka-based lawyer, lodged a formal petition with the Constitutional Court. The respondents named in this petition are none other than President Hakainde Hichilema himself and the Attorney General of Zambia. But to understand how we arrived at this explosive moment, we need to rewind to March 8, 2025. It was International Women's Day, and President Hichilema was addressing celebrations when he announced something significant. His government would commence a constitutional amendment process. At the time, it seemed like a policy announcement, perhaps even a progressive step forward. Then, the Attorney General moved quickly. Through a ministerial statement delivered by Justice Minister Princess Kassoon, the government confirmed that a draft of the proposed amendments had already been produced and was on track to be tabled in Parliament. This is where the controversy deepened. According to the petitioners, on May 23, 2025, the government caused Bill No. 7 of 2025 to be published in the Zambia Gazette. But here's the critical issue. The petitioners argue that these actions were taken without conducting what they call wide and inclusive consultations with citizens or relevant stakeholders. The situation became even more complex because there was already a pending matter before the Constitutional Court. A previous case, referenced as Mukandala and Munir Zulu versus Hakainde Hichilema and Attorney General, case number 2025/CCZ/009, had asked the Constitutional Court to determine the legality of the government's decision to amend the Constitution without broad public consultation. The petitioners now argue that by proceeding with Bill No. 7 despite this ongoing legal challenge, President Hichilema acted in defiance of the court's authority and in contempt of its judicial process. The petition filed by Mundubile and Mukandala doesn't mince words. Let me read you directly from the legal filing as reported. The petitioners argue that President Hichilema and the Attorney General acted unconstitutionally by initiating a constitutional amendment bill without conducting wide and inclusive consultations with citizens or relevant stakeholders. They go further, stating that this conduct contravenes Articles 8, C, and E, 9, 90, 91, 3, A, and 92(1) of the Constitution. Now, these aren't just procedural violations in their view. The petition makes a far more serious claim. According to the filing, these actions amount to defiance of the court's decision and constitute a clear breach of the president's constitutional obligations. And here's the hammer blow in the petition. The petitioners maintain that President Hichilema's conduct renders him ineligible to contest any future election, including the 2026 general election. The petition specifically alleges that President Hichilema breached his oath of office to protect and uphold the Constitution, and that this breach disqualifies him from seeking re-election as Republican president. The petitioners are seeking several declarations from the Constitutional Court. They want the court to declare that, by acting in contempt of the Constitutional Court's judgment, the president has disqualified himself from holding or contesting the office of president. They're also seeking a declaration that President Hichilema's conduct renders him ineligible to stand in any future election, and that Bill No. 7 of 2025 remains null and void. Now, the response from the political sphere has been swift and divided. Critics of the petition have been vocal. One commentary captured in the reporting stated, "Mundubile has erred because he is acting illegally as a judge when he is a politician. The case will be thrown out because UPND government complied with Constitutional Court observations and directives. This is an attempt to get power through a non-existent legal backdoor." Another respondent wrote, "Bitterness and malice. These chaps know that HH is winning next year, so now they are trying other tactics to remove him from the equation. For your own information, Mr. Mundubile, even late ECL tried to eliminate HH, but this failed." The government's position, as reflected in public commentary, is that the Constitutional Court guided. The consultative part of Bill 7 is ongoing. There is nothing that warrants or can be converted to presidential ineligibility. But supporters of the petition see it differently. One analysis stated, when the case against Edgar Chagwa Lungu's eligibility was taken to the Constitutional Court, no one talked about hatred or bitterness. Here we are today, and surely there were some constitutional breaches committed by Mr. Hakainde Hichilema regarding Bill 7. And the Constitutional Court ruled so. This legal challenge arrives at a particularly sensitive moment in Zambian politics, less than a year before the August 2026 general elections. The irony is not lost on political observers. President Hichilema himself spent years navigating constitutional challenges and electoral controversies. His predecessor, Edgar Lungu, faced a constitutional court case that ultimately declared him ineligible to run again. Now, the tables may be turning, though the circumstances are entirely different. The constitutional articles cited in the petition are significant. Articles 8, C, and E deal with the national values and principles that bind the government. Article 9 addresses the supremacy of the Constitution. Articles 90 and 91 concern the executive authority and the president's functions, while Article 92 deals with the president's oath of office. The central legal question is this: can a president be disqualified from holding office based on alleged violations of constitutional procedure in how amendments were pursued? There's also a broader question about the role of the Constitutional Court. Is it appropriate for the court to preemptively disqualify a sitting president from contesting future elections, or should such matters be resolved through the electoral process and public accountability? Opposition parties and civil society organizations have varied reactions. Some see this as a legitimate exercise of constitutional accountability, ensuring that even the highest office is subject to the rule of law. Others view it as political theater, a desperate attempt by a fragmented opposition to remove through the courts a candidate they cannot beat at the ballot box. The timing is also significant. With Zambia facing economic challenges, including load shedding and rising prices, the opposition arguably has substantive policy grounds to challenge the incumbent. Yet, they've chosen a legal strategy focused on constitutional procedural violations rather than campaigning on bread and butter issues. One political analysis noted that the president stands on governance challenges. They stand on organizational vacuum. The suggestion being that while Hichilema faces legitimate criticism over service delivery, the opposition lacks the organizational capacity to convert public frustration into electoral success. There's also the question of precedent. If this petition succeeds, it would set a remarkable precedent that constitutional amendment procedures, if improperly conducted, can be grounds for presidential disqualification. This could fundamentally change how future governments approach constitutional reform. Legal experts are divided. Some argue that the Constitution is clear about the need for consultation, and if the government violated this requirement despite a pending court case, there should be consequences. Others contend that the remedy for such violations might be to nullify the bill, not to disqualify the president personally. What's undeniable is that this case will test Zambia's constitutional framework and the independence of its judiciary at a critical moment. So there you have it, viewers. A constitutional showdown that could reshape the entire 2026 presidential race. Brian Mundubile and Celestine Mukandala have thrown down the gauntlet, asking the Constitutional Court to do something unprecedented. Bar a sitting president from seeking re-election based on alleged constitutional violations in how he pursued constitutional amendments. The Constitutional Court now faces an enormous responsibility. Its decision will not only determine President Hichilema's eligibility but will also send signals about the limits of executive power, the importance of constitutional procedure, and the role of the judiciary in checking political authority. For President Hichilema, this is perhaps the most serious legal challenge of his political career. For the opposition, it's a high-stakes gamble that could either remove their strongest opponent or backfire spectacularly. For Zambia, it's a test of democratic institutions and the rule of law. Thank you so much for watching this edition of InspirAfrica Official. This is a developing story, and we'll be following every twist and turn as it unfolds. What do you think about this constitutional challenge? Is this legitimate accountability or political desperation? Do you believe the Constitutional Court should have the power to disqualify a sitting president before elections? We want to hear from you in the comments below. Don't forget to like this video, subscribe to our channel, and hit that notification bell so you don't miss any updates on this explosive story. We'll be back tomorrow with more news, more analysis, and more of the stories that matter to Africa. Until then, this is Nakash, signing off. Stay informed, stay engaged, and stay inspired.